I don't meet with support staff. 5 words, said casually, almost dismissively, in front of 47 witnesses with cameras rolling. 5 words that would eventually cost $7.3 million and destroy multiple careers. But I'm getting ahead of myself. I was standing near the back of the conference room, holding a portfolio folder and trying to look like I belonged there. Which I did. I'd worked at Meridian Capital for 7 years. Started as an operations analyst, worked my way up to senior coordinator. Not glamorous, but essential. The kind of role where if I disappeared tomorrow, 3 departments would collapse by Friday. The room smelled like expensive coffee and ambition. But in rooms like this, with mahogany tables and leather chairs that cost more than my monthly rent, people like me were usually invisible. Today was different. Today was the introduction event for our new managing director. The position had been vacant for 4 months after the previous director retired. The firm had conducted a national search, interviewed dozens of candidates, and finally selected someone with an impressive resume from a competitor firm. I'm Jason, 36 years old. I handle compliance documentation, vendor contracts, and operational risk assessments. Not exciting work, but it keeps a $12 billion investment firm from getting sued into oblivion. My job is knowing what regulations apply, when they apply, and making sure everyone follows them, including managing directors, especially managing directors. The room was filling up, senior partners in their perfect suits, vice presidents checking their phones, junior analysts standing along the walls trying to look engaged. The new managing director was supposed to arrive any minute, and the firm's owner, the man who'd built Meridian Capital from nothing 30 years ago, was already holding court near the front. His name doesn't matter. What matters is that he controlled 68% of the firm's equity and made every major decision. What he said was law. What he wanted happened. And what he believed about how things should be done shaped the entire company culture. I'd interacted with him maybe 5 times in 7 years. Brief exchanges, polite nods. The kind of acknowledgement you give someone you don't really see as important. The door opened, and the new managing director walked in. Confident, stride, expensive watch. That particular kind of smile that comes from knowing you've just been handed significant power. People applauded politely. The owner shook his hand, clapped him on the shoulder, started making introductions. I waited. No rush. I'd introduce myself when the initial crowd thinned. That was protocol. Let the senior people go first, then work your way in. Basic corporate hierarchy. But as I watched, something started bothering me. The owner was introducing the new director to specific people. Senior partners? Yes. Vice presidents? Absolutely. But he was skipping people. Junior analysts standing right there, hands half extended, being completely ignored. I recognized the pattern. I'd seen it before in different forms. The subtle sorting of who matters and who doesn't based on title, on perceived importance, on hierarchy that had nothing to do with actual contribution. It was discrimination. Not the obvious kind. Not the kind that gets reported. The quiet kind. The kind that happens in plain sight and everyone pretends is normal. The crowd was thinning. I stepped forward, extending my hand toward the new managing director. Jason, Senior Compliance Coordinator, I said clearly. Welcome to Meridian. The managing director started to reach out, that automatic handshake reflex, but the owner cut between us. Physically stepped in front of me like I'd done something wrong. I don't meet with support staff, he said. Not to me, to the managing director. Like I wasn't standing right there. The room went quiet, not dramatically. Just that subtle shift where conversations pause and people's attention redirects without them fully realizing it. I stood there, hands still extended, and felt something cold settle in my chest. The owner continued, voice carrying that casual authority of someone who's never been contradicted. You'll meet the operations team during your departmental briefings. Right now, let's focus on the strategic relationships. Strategic relationships, code for people who matter. I lowered my hand slowly. The managing director looked uncomfortable but said nothing. He'd been here less than 10 minutes. He wasn't going to contradict the owner on his first day. Several people had their phones out. This was an official introduction event. People were taking photos, recording video for the company's internal communications, standard practice for major announcements, which meant what just happened was documented. I smiled. Not forced. Genuine. Because the owner had just made a catastrophic legal mistake and didn't realize it. Perfect, I said, voice calm, conversational. That statement just activated $7.3 million in discrimination damages. Dead silence. The real kind this time. The kind where you can hear the ventilation system humming and someone's phone buzzing on silent mode. The owner turned to look at me fully for the first time. Excuse me? Title VII of the Civil Rights Act prohibits employment discrimination based on race, color, religion, sex, or national origin, I said, keeping my tone professional, almost friendly. But it also prohibits creating a hostile work environment through patterns of behavior that establish class-based hierarchies. What you just did, publicly refusing to acknowledge an employee based solely on their job classification, in front of witnesses, on camera, constitutes hostile work environment creation under federal employment law. The owner's expression shifted from confused to annoyed. That's absurd. I was prioritizing introductions. You were establishing that support staff, your words, don't merit professional courtesy from executive leadership. That creates a protected class based on job title, which becomes actionable discrimination when it affects terms and conditions of employment. Which this does, because access to leadership directly impacts promotion opportunities, project assignments, and career advancement. Someone in the back coughed. Several people were now very intentionally not looking at me. The owner's face was getting red. You're overreacting to a simple comment? I'm citing federal employment law. And the damages number I mentioned? That's based on recent case precedent. Morrison versus Techmark Industries, settled last year. Senior executive publicly dismissed employees as not worth his time based on their departmental classification. Company settled for $6.8 million. That was for one incident with 4 witnesses. This is one incident with approximately 47 witnesses and video documentation. I could see the owner processing this, see the moment he realized I wasn't making this up, that I actually knew what I was talking about, that my job for the past 7 years had been knowing exactly this kind of thing. Are you threatening to sue this firm? He asked, voice dangerous now. I'm explaining the legal liability you just created. What happens next is up to you. Quick pause. I need you to understand something before we go further. What I just did in that room was possible because I spent 7 years learning employment law, compliance regulations, and case precedent. Most people in that situation would have just walked away feeling humiliated. If you're in corporate America and you don't know your rights, you're vulnerable. Comment rights below if you've ever been in a situation where you wish you'd known what you were legally entitled to. Because what happened in the next 72 hours only worked because I knew exactly what cards I was holding. The owner stared at me for a long moment. Then he turned to the new managing director. Let's continue the introductions in my office. They left. Most of the senior people followed. The room cleared quickly, people suddenly remembering they had urgent meetings or calls to make. Within 2 minutes, I was standing there with maybe 5 other people. All of them junior staff who looked at me like I'd just detonated a bomb. Did you really just threaten to sue the owner? One of them whispered. I didn't threaten anything. I stated facts. You're going to get fired. Maybe. But if I do, that's retaliation, which adds another layer of liability. I left the conference room and went back to my desk. Sat down, opened my computer, started documenting everything that had just happened while it was fresh. Exact words, exact timeline. Who was present? What was said? What was recorded? My phone rang 30 minutes later. Internal extension, HR. We need you to come to a meeting, the voice said. Female, professional, the careful tone that means something serious is happening. When? Now, conference room B. I saved my documentation, emailed it to my personal account, and walked to conference room B. 2 people from HR were there. The head of HR, a woman I'd met maybe twice, and someone I didn't recognize who was probably from legal. Sit down, Jason, the head of HR said. I sat. We need to discuss what happened in the introduction event this morning. Okay. Several people reported that you made inappropriate comments about potential legal action against the firm. I didn't make any comments about legal action. I explained the legal implications of what the owner said. You mentioned a specific damages number, $7.3 million. $7.3 million, yes. That's based on Morrison versus Techmark Industries case precedent. Similar fact pattern, similar company size, adjusted for inflation and case outcome trends over the past 18 months. The person from legal, I was now certain he was legal, leaned forward. You're not an attorney. No. I'm a compliance coordinator. My job is understanding employment law, discrimination statutes, and regulatory liability, which I do. That's why you hired me. Your job is coordinating compliance processes, the head of HR corrected, not providing legal opinions. I didn't provide a legal opinion. I cited case law. There's a difference. The legal person exchanged a glance with the HR head. The owner felt your comments were inflammatory and disruptive. The owner's feelings don't change federal law. No, the legal person agreed. But they do affect your employment status. There it was, the threat, subtle but clear. Are you terminating me? I asked. We're considering what disciplinary action is appropriate. For what violation specifically? Insubordination, creating a hostile work environment, disrupting a corporate event. I almost laughed. Almost. I'd be very careful about moving forward with any disciplinary action right now. Because whatever you put in writing becomes evidence in the discrimination claim that's going to be filed within the next 48 hours. You said you weren't threatening legal action, the HR head said sharply. I'm not threatening. I'm informing. Whether I file or someone else files, the incident this morning is now documented. Multiple witnesses, video evidence, clear pattern of behavior. Any adverse employment action taken against me within the next 6 months becomes prima facie evidence of retaliation. That's not a threat. That's how employment law works. Silence. The legal person spoke carefully. What outcome are you looking for here? I'm looking for the firm to comply with federal employment law, which means treating all employees with professional respect regardless of their job classification. Which means not publicly dismissing people as beneath notice based on their title. The owner didn't dismiss you, the HR head protested. He said, and I'm quoting exactly, I don't meet with support staff in front of 47 witnesses. While being recorded, that's textbook hostile work environment creation based on job classification. If you don't believe me, I suggest you consult with outside employment counsel before taking any further action. The legal person stood up. We'll be in touch. I went back to my desk, sat there for maybe 10 minutes, heart pounding, hands shaking slightly. Because what I'd just done was either brilliant or career suicide, and I wouldn't know which until someone made the next move. My phone buzzed. Text from a coworker who'd been in the introduction event. Holy shit. Everyone's talking about what you said. Owner is furious. You okay? I didn't respond. Another text. Different coworker. Legal is freaking out. They're reviewing video footage from this morning. What did you do? Still didn't respond. A third text. This one from a number I didn't recognize. This is Barbara Klein, employment attorney. I represent 3 current employees at Meridian Capital in various matters. I heard about this morning's incident. I'd like to speak with you if you're interested. No obligation. I stared at that message for a long time. Then I called the number. Barbara Klein was 62 years old, had been practicing employment law for 34 years, and when I explained what happened, she was quiet for almost 15 seconds. Then she said, How many people witnessed this? Approximately 47. And it was recorded? Multiple phones, plus the official company recording for internal communications. And you cited Morrison versus Techmark? Yes. Did you cite it correctly? 6.8 million settlement, publicly dismissed employees based on departmental classification, 4 witnesses. I scaled up for increased witness count and video evidence. Another pause. Then, Jason, I'm going to be very direct with you. What you have is an extremely strong hostile work environment claim based on job classification discrimination. But there's a problem. What problem? Job classification isn't explicitly a protected class under Title VII. Race, color, religion, sex, national origin, those are protected. Job title isn't. My stomach dropped. But Morrison versus Techmark was a race discrimination case that happened to involve job classifications. The employee who sued was dismissed based on what the court determined was actually coded racial bias disguised as job hierarchy. The classification issue was evidence, not the cause of action. I closed my eyes. So I was wrong. You were partially wrong. Job classification alone isn't protected, but creating hostile work environments based on any pattern of conduct that affects employment terms can be actionable. And if we can show that job classification correlates with any protected characteristic, race, age, sex, we have a path forward. What are the chances? Honestly, maybe 40%. But there's something else. What? Meridian Capital is a federal contractor. You process government compliance documentation, correct? Yes. Then the firm is subject to Executive Order 11,246, which prohibits federal contractors from discriminating based on additional classifications beyond Title VII, including, in some interpretations, organizational hierarchy used to create hostile environments. My heart started pounding again. So, the 7.3 million number is probably inflated but not impossible if we litigate and win. More realistically, if they're smart, they settle for somewhere between 1.5 and 3 million to avoid discovery, depositions, and public exposure. And if they're not smart, then we take it to court, and either we win big or we lose and you're out legal fees. I sat there in my cubicle, phone pressed to my ear, doing math in my head. What would you charge? I asked. Contingency. 33% of any settlement or judgment. You pay nothing unless we win. What happens if I do nothing? Then you probably get fired within the next 2 weeks for some pretextual reason. You sign a release in exchange for standard severance and nothing changes. I thought about the owner's face when he'd dismissed me. Thought about the junior analysts he'd ignored. Thought about 7 years of watching people treated differently based on where they sat in the hierarchy. Let's do it, I said. Barbara Klein filed the complaint 3 days later. Hostile work environment, discriminatory conduct, retaliation. She named Meridian Capital and the owner personally. She cited the introduction event, the HR meeting, the pattern of conduct, and she requested damages, attorney fees, and injunctive relief requiring policy changes. The firm's response was immediate. I was placed on administrative leave pending investigation, paid leave, which Barbara said was them trying to avoid additional retaliation claims. I was told not to come to the office, not to contact coworkers, not to discuss the matter publicly. I spent 2 weeks at home, watching daytime television and checking my phone obsessively. Then the calls started. Not from Meridian, from other employees. I heard what you did. I've been here 9 years and I've seen the same thing happen to dozens of people. Can I talk to your lawyer? I was in that meeting. I recorded it on my phone. Do you need the video? I'm a black woman in operations. I've been passed over for promotion 6 times while white men with less experience got elevated. Is that related to your case? Barbara's phone was ringing off the hook. Within 3 weeks, she had 8 additional plaintiffs, all operations staff, all with documented incidents of being dismissed, ignored, or explicitly told they weren't important enough to interact with senior leadership. What started as one hostile work environment claim became a pattern and practice discrimination case. Meridian Capital hired a major law firm to defend them. Expensive attorneys who filed motions to dismiss, argued the case had no merit, claimed everything was taken out of context. But they couldn't dismiss the video. 47 witnesses, the owner's exact words. I don't meet with support staff. Discovery was brutal. Barbara subpoenaed personnel files, promotion records, salary data, performance reviews. What she found was a documented pattern of operations, staff being paid less, promoted less, and given fewer opportunities than employees in client-facing roles, even when their performance metrics were identical. She found emails where senior leaders explicitly discussed not wasting time with support people. She found meeting notes where operations staff were deliberately excluded from strategic discussions. She found a culture of hierarchy that went beyond normal corporate structure into systematic devaluation of an entire class of employees. The case went to mediation 8 months after filing. Federal magistrate, neutral location, both sides with their attorneys. The magistrate listened to opening statements, reviewed key evidence, and then said something I'll never forget. I've been doing this for 23 years. I've seen a lot of employment discrimination cases. Most of them are subtle, hard to prove. This one is on video, with 47 witnesses, and a named executive saying explicitly that he doesn't engage with certain categories of employees. I'm going to be very clear with both parties. This is going to trial unless we settle today. And if it goes to trial, the plaintiff is going to win. Meridian's attorneys asked for a private caucus. We waited in a separate room for 2 hours. When they came back, they had a number. $2.8 million. Split among all 9 plaintiffs, plus policy changes, plus mandatory training, plus an independent monitor for 3 years. Barbara looked at me. I looked at the other plaintiffs. We all nodded. The settlement was finalized 6 weeks later. After legal fees and taxes, my share was approximately $470,000. Life-changing money. Enough to pay off debt, buy a house, have security I'd never had before. But the money wasn't the point. Not really. The point was that the firm had to send a company-wide email acknowledging that all employees, regardless of job classification, deserved professional respect. They had to implement new policies prohibiting hierarchy-based discrimination. They had to fire 2 senior executives who'd been the worst offenders in depositions. And the owner, the man who dismissed me as support staff not worth his time, had to stand up at a company meeting and apologize. On camera. In front of everyone. Here's something nobody tells you about cases like this. The settlement money is great, but what actually changes things is the fear. Because now every executive at that firm, and every executive at every firm who heard about this case, knows that dismissing employees based on job classification can cost millions. That casual hierarchy, that automatic dismissal of people you think don't matter, has a price tag. If you've ever been treated like you don't matter at work, comment below with just your job title. No explanation, just the title. I want to show how common this is. I didn't go back to Meridian Capital. The settlement included a separation agreement. I left, took my money, and spent 3 months figuring out what came next. Other firms reached out, wanted to hire me for compliance roles, wanted someone who understood not just the regulations but how they applied in practice, someone who'd actually stood up when it mattered. I took a position at a smaller firm. Better title, better pay, better culture. And every time I walk into a meeting now, I notice how people greet each other. Who gets acknowledged? Who gets ignored? Who matters and who doesn't? And if I ever see that pattern starting, that casual dismissal of people based on where they sit in the hierarchy, I speak up. Not because I want to sue, because I know what happens when nobody does. The owner settled with us, but he fought 3 more discrimination cases in the following 2 years. Different plaintiffs, similar patterns. Eventually, he was forced out by the other partners. The culture he'd built became too expensive to maintain. I heard through former colleagues that the firm is different now. Not perfect, but better. People get acknowledged regardless of their title. Meetings include operations staff. Promotions consider performance, not just role classification. Because one introduction event, one public dismissal, one moment of casual discrimination captured on 47 cameras cost them $2.8 million. And that's expensive enough that even people who don't care about doing the right thing care about avoiding that cost. If you made it this far, I want you to do something specific. Next time you're in a meeting at work, any meeting, count how many people get greeted by name and how many get ignored. Just count. Don't say anything, just notice. Then come back here and tell me the number. Because awareness is the first step. And if enough people start counting, start noticing, start documenting, the culture shifts. Not because people suddenly become better humans, but because they realize the cost of being casual about hierarchy is higher than they want to pay.